Okay, the meeting's called to order. And now we're going to appoint the commissioners. So if you'd please come on up here. I guess we need a roll call first, or do you want to swear them first?
Go ahead and do the oath first.
Okay, great. But I'm in a half circle? How do you want?
Half circle, facing the audience, and then
Like this?
Everybody out there can see them.
So are we good? All right, good. Okay, I, your name, do solemnly swear that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, and that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. Thank you. Okay, take your seats here. So I'm out of this now, right? Okay, great. Thank you. I'm not done after all. What do I know? Okay, each of the commissioners, would you give us a brief introduction? Tell us a little bit about yourself, and then we're going to elect a chairman, and then you're on your way. Okay.
Would you like to start on this end? Is this mic on? I can't tell. My name is David Vieira. I'm currently the superintendent of the Antelope Valley Union High School District. I've been with the district for approximately 21st year right now. I'm a product of the district as well, a native of the Antelope Valley, and honored to be here today and look forward to serving on this commission with my colleagues here.
Do you want to make sure all your microphones are on, because the cameras are rolling and you're being downloaded on the internet? Maybe also on the city station.
My name is Chris Johnson, and I'm the senior pastor at Grace Chapel. And I have served there for 9 years. I formerly was the principal at Desert Christian High School and was at that school for 9 years previous. I am involved in many community activities in local neighborhoods and with Grace Resource Center, and also privileged and honored to be asked to be on this commission, and will serve faithfully.
Hi, good morning. My name is Greg Augusta. My career path has led me a 33-year career in law enforcement. Worked for the California Highway Patrol and served in a number of different commands and assignments throughout the state. When I retired in 2005, I was the assistant commissioner charged with daily operation and field operations for the Highway Patrol. I'm excited about serving on this commission. We worked with the Antelope Valley War on Gangs, a grassroots effort to really begin to address some of the issues up here involving crime. Mayor Paris has certainly taken a leadership role. I appreciate the opportunity to be a part of this committee, and I see some pretty good results that we can achieve through some hard work and collaborative effort. Thank you.
My name is Marvin Christ. I'm a resident of the Antelope Valley. I was born and raised here, as some of my other colleagues were. I'm a insurance broker by trade. I am president of the Antelope Valley Sheriff Boosters. I work with Captain Anderson regularly on different stuff. I am excited about what the mayor has done for the city so far. I'm excited about this commission, and we're ready to get to work. Thank you.
I'm Dennis Greer. I've lived here for 45 years. My family transferred up here when I was very young. My dad transferred with LA County Sheriff's Department to this station in about '64. I'm a product of the local schools as well as the local college, and I've served and worked at Coldwell Banker Hartwig Realty for the last 29 years. I'm looking forward to working with all the members on this commission and everyone in the community. Thank you.
I'm Mark Brown, and I'm currently the chairman of the emergency department at Antelope Valley Hospital. I've been at the hospital there for 22 years. The nice thing about working in the emergency room is that I can look forward to seeing each of you sooner or later in the emergency room. I look forward to being on this commission. I think, at least in terms of how law enforcement interacts with the emergency room, which is a daily occurrence, we can come up with some solutions that will make that function more smoothly. Thanks.
We should do a roll call now. We kind of skipped over that, so I'll do a roll call if you'll just say here. Commission members Augusta?
Here.
Brown?
Here.
Christ?
Here.
Greer?
Here.
Johnson?
Here.
Vieira?
Here.
We have a quorum. At this time, I would like to open up the nomination for chairman of the Criminal Justice Commission. We need a motion from one of the commissioners for chairman.
I would like to make a motion that we appoint Greg Augusta as the chairman of the Criminal Justice Commission.
And do we have a second?
I'd second that.
And all in favor say aye.
Aye.
Opposed? Okay. Thank you. We'd now like to open up the nominations for a vice chairman.
I'd like to nominate Marvin Christ.
And a second.
I'll second that motion.
All in favor?
Aye.
Opposed? Okay, thank you.
This time, we would like to receive a presentation regarding the Brown Act from Deputy City Attorney Joe Adams.
Good morning, Mr. Chairman and members of the Commission. My name is Joe Adams. I'm a Deputy City Attorney with the City Attorney's Office. This morning, I want to just take a few minutes of your time to provide you with a brief overview of the Brown Act, which is California's open meeting law. I'm sure that some of you are already familiar with it. I'm not sure the extent to which each of you are. So my presentation is going to be maybe very basic and remedial to some of you, and if it is, I apologize for that. I've provided each of you with a bound booklet. It's entitled the Ralph M. Brown Act. I've also provided each of you with one of my cards just under the front cover of this booklet. And the reason that I did that is because although I'm going to provide a very brief summary of the Brown Act this morning, there will certainly be questions that arise as time goes on as to certain provisions, or there certainly will be questions that arise in the future, and I wanted to provide you with an easy way to contact me in those cases. I could always be reached at any of those numbers or by email, so feel free to do that, please. In the booklet, the first document that's contained in the booklet, and I apologize, by the way, that there aren't tabs. I had requested tabs, and instead I've got these colored pages that separate each of the three documents, and I apologize for that. But the first document is a summary that I've prepared. This summary follows the format that you will see most summaries of the Brown Act follow. It's a logical format and follows the organization of the Act itself. The Act is actually rather logically organized. I'm going to basically provide you this morning with a summary of my summary. The summary that I provided you with will probably go into a little bit more detail than what I'm going to go into this morning. The second document in the booklet is the actual act. It's the statutory sections. If you would like to, and I would encourage you to go through the act itself. It's not very long. It's, like I said, it's pretty logically organized. And so I would recommend at some point, probably sooner rather than later, that you go through the act. The third document is a document that's been published by the California Attorney General's Office. It's also entitled the Brown Act. There's a couple of things I need to warn you about this document. This is a very useful document. It provides a lot of useful discussion regarding the Brown Act. It will probably honestly address a lot of questions that you may have as time goes on. So I feel it's a useful document. That's why I've provided you with a copy of it. I do want to warn you, however, this document was published in 2003. And it's the Attorney General's Office, it's their most recent version of this document. So while it does provide a good starting point for any questions that you may have, I would encourage you to take a look at the statutory language itself or give me a call if you have any specific questions. But because I do feel that it provides some useful information, some useful discussions, I have provided you with a copy of it. Okay, so to go right into the summary, I think that it's most important to realize what the intent of the act is. The act, and I don't think that the intent of the act is stated any more clearly than in the act itself in its purpose and intent section, which provides in part, the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist in remaining informed so that they may retain control over the instruments they have created. I think that's a pretty clear statement of the intent of the Brown Act. And I think that from that intent you can probably reach a conclusion as to what the act requires without even getting into the act. It, in short, requires that meetings be held open to the public, that meetings be noticed, that by way of agenda and otherwise, and that public bodies, legislative bodies, do not act or deliberate on or consider any matters that aren't contained on an agenda that are being acted on, deliberated on, or considered in an open public meeting. And the purpose for that very clearly is to allow public participation in the meetings of legislative bodies. And public participation in the form of knowing what the meeting will include so that members of the public can simply attend if they choose, and also knowing what will be considered and deliberated on at the meeting so that those members of the public can actually participate in the meeting in sort of a more affirmative manner than simply attending. A lot of questions that you may have in the future regarding the Brown Act could probably be answered by simply referring back to its intent. If you have any questions in the future as to what the Brown Act requires or what the Brown Act prohibits, if you just look back at the intent, you'll probably be able to reach the right conclusion or pretty close to it. The first logical question when considering the Brown Act is to look at what bodies are covered by the Act. The Act governs the meetings of legislative bodies of local agencies. And so then what is a legislative body? And the Act defines a legislative body as the governing body of a local agency or other local body created by statute, state or federal statute. And two, a commission, committee, board, or other body of a local agency, whether permanent or temporary, decision-making or advisory, created by charter, ordinance, resolution, or formal action of a legislative body. This commission was created by formal action of the City Council. This commission then therefore, under the Brown Act, for purposes of the Brown Act, is a legislative body and is subject to the requirements of the Brown Act. The next section is what is a meeting, and the reason why this section is so important is because the Brown Act governs meetings. If you don't have a meeting, then the Brown Act and the requirements and the prohibitions of the Brown Act usually don't apply. So the question of what constitutes a meeting is sort of the threshold issue when doing a Brown Act analysis. And a meeting is a congregation of a majority of the members of a legislative body at the same time and place to hear, discuss, deliberate on any item that is within the subject matter jurisdiction of the legislative body. So you can see the Brown Act defines a meeting very broadly. A meeting does not have to be formal. A meeting does not have to be held in this chamber. If there are a majority of you present at any location, at any time, at any place, and you are discussing, deliberating on, hearing, considering anything that is within the subject matter jurisdiction of this commission, then for the purposes of the Brown Act, a meeting has occurred or is occurring. And then that triggers a whole lot of requirements under the Brown Act, notice requirements, agenda requirements. And to the extent that a meeting is held outside a formal meeting, and by that I mean a meeting that has been noticed and a meeting for which an agenda has been prepared, to the extent that a meeting occurs outside of that context, a lot of requirements of the Brown Act, such as the notice and agenda requirements, probably are not being satisfied, and there's a problem. I think for this commission, and we'll be talking very briefly about closed session items. We'll be talking about a lot of things that probably won't matter as much to this commission as the definition of meeting. And what we really would like to do is to avoid holding a meeting inadvertently. And as odd as that sounds, it's completely possible to inadvertently hold a meeting. And it's probably one of the more common violations of the Brown Act, at least in my view. There's a number of things that the Brown Act specifically excludes from the definition of meeting, and I think that I'll briefly mention each of them. I think that you'll notice with a lot of these exceptions, they aren't so much exceptions to the Brown Act as being situations that simply don't satisfy the requirements or the elements of a meeting. And again, a meeting is congregation of a majority of in this case, the commission, at which you are discussing, deliberating on, considering anything within the subject matter jurisdiction of the commission. The first exception is individual contacts or conversations between a member of a legislative body and any other person. This would be conversations that you would have with members of the public. Any other person, for purposes of this exception, does not include other members of this commission or members of the city staff. We'll get into that issue in just a second. That creates a serial meeting problem. So when you see that the Brown Act accepts from the definition of meeting individual contacts with any other person, generally speaking, that includes members of the public, not members of the commission, not members of the city staff. 2, attendance of a majority of the members of the legislative body at a conference or similar gathering open to the public that involves discussion of issues of general interest to the public or to the public agencies of the type represented by the legislative body, provided that a majority of the members do not discuss among themselves, other than as a part of the scheduled program, business of a specified nature that is within the subject matter jurisdiction of the local agency. These are training sessions, conferences, those types of things at which a majority of you will be, is permissible. It's not a meeting, and you can discuss matters that are within the subject matter jurisdiction of this commission so long as those discussions are a regular part of that training session or conference. The third is attendance of a majority of the members of the legislative body at an open and publicized meeting organized to address a topic of local community concern by a person or organization other than the local agency, provided, again, that a majority of the members do not discuss among themselves, other than as a part of the scheduled program, business of a specified nature that is within the subject matter jurisdiction of the legislative body. It's a very similar exception to the previous. The fourth is attendance of a majority of the members of a legislative body at an open and noticed meeting of another body of the local agency. So that would be another body of the city, or at an open and noticed meeting of the legislative body of another local agency, provided that a majority of the members do not discuss among themselves, other than as a part of the scheduled meeting, business of a specified nature that is within the subject matter jurisdiction of the legislative body of the local agency. The fifth is attendance of a majority of members of a legislative body at a purely social or ceremonial occasion, provided that a majority of the members do not discuss among themselves business of a specified nature that is within the subject matter jurisdiction of the legislative body of the local agency. There's a common theme. All of these things are exceptions, but you cannot discuss matters that are within the subject matter jurisdiction of this commission, except in other noticed meetings or in conferences when that is a part of the scheduled conference or when that is a part of the scheduled meeting. For the purposes of social gatherings or ceremonial events, you simply cannot discuss or talk about matters within the subject matter jurisdiction of the commission. And that's not with other members of the public. That would be with a majority of the commission. So if a majority of the commission happened to be at a social event, that would be permissible under the Brown Act. It wouldn't constitute a meeting unless the majority of the commission began discussing matters within the subject matter jurisdiction of the commission. And in that case, the two elements of the meeting definition have been satisfied. And that's why I really don't consider that to be an exception to the meeting definition. Those circumstances simply don't, most of those circumstances anyway, simply don't satisfy the requirements of a meeting because the members of the commission or the majority of the members of the commission are not discussing matters within the subject matter jurisdiction of the commission. And the final exception is attendance of a majority of the members of a legislative body at an open and noticed meeting of a standing committee of that body, provided that the members of the legislative body who are not members of the standing committee attend only as observers. That exception would only apply if this commission were to create standing committees. Probably when discussing what constitutes a meeting, the most important thing to remember and keep in mind is the concept of the serial meeting. And the serial meeting, and the Brown Act doesn't use the term serial meeting, but that's what everybody refers to this as. And those are circumstances when members of the commission use means, for example, email or telephone calls, something of that nature, and discuss matters within the subject matter jurisdiction of the commission with one other member of the commission. You don't have a meeting in that case because you don't have a majority of the members of the commission, a quorum basically, that are engaged in the discussion. So that would be permissible. But in order to prevent legislative bodies from circumventing the requirements of the Brown Act would also prohibit then and there's a number of different forms that this can take. But for example, the commission member A calls member B. Commission member B then calls commission member C. Member C calls member D, and so on. And you have a sort of a chain meeting, although there never is at any one point in time a majority of the commission discussing the matter. There, in effect, is. And that would be, a serial meeting sort of the chain variety. There's also a hub and spoke type where you have member A calls member B, member A then calls member C, member A then calls member D, and that creates the same problem, the serial meeting problem. And you've essentially conducted a meeting, but you've conducted a meeting in such a way that there is not a majority of the commission members ever discussing the topic at the same time. That would be impermissible. That would be a serial meeting. So, and that's the type of thing that could probably occur very unintentionally, very easily. So that's something to keep in mind. And again, the reason it's so important to know what exactly constitutes a meeting is because if a meeting is occurring, or if a meeting has occurred, or if a meeting will occur, there are certain requirements that must be satisfied, not the least of which are notice and agenda requirements. And you'll see my summary. I summarized the notice and agenda requirements. For your purposes, I believe the city clerk's office will be preparing the agenda, will be posting the agenda. Most of the notice and agenda requirements will be satisfied by city staff, preparing the notice, posting the notice, things of that nature. It's very important to know, though, with respect to the agenda requirement, at your meetings, the commission is limited to discussing, considering, deliberating on matters that are contained or specified on the agenda. Essentially, your meeting is limited to what's on the agenda. There is certain limited, very limited exceptions to that. If a member of the public, for example, was to speak and was to raise some issues, and a member of the commission wanted to ask city staff to clarify something that's been raised by a member of the public, or if a member of the commission directed city staff to look into an issue that was raised by the public during the meeting that's not on the agenda, that would be permissible. Beyond that, discussing the commission itself discussing an item that's been raised by a member of the public that's not contained on the agenda would likely run afoul of the Brown Act. Certainly, taking that a step further and taking any action on an item that was raised at a meeting by a member of the public that's not contained on that meeting's agenda would be a problem. So there likely will be members of the public that raise issues that are not on your agenda. And the right of the public to raise matters that are within your jurisdiction but that are not contained on the agenda is in the Brown Act. So members of the public absolutely have the right to do that. But what's done with that is certainly up to the commission. If the commission wanted to seek clarification on that or wanted to direct staff to look into something that was raised, that's perfectly fine. But considering it beyond that, deliberating on an issue beyond that, and certainly taking any type of action on an issue that's not specifically agendized is a problem. I'll briefly touch on special meetings and emergency meetings. The regular meetings of the commission will be established by, or are established by resolution, but the commission can also hold special meetings and emergency meetings. Special meetings, and the difference between a special meeting and a regular meeting, I consider there to be two primary differences. One is the noticing requirement, and two is the agenda requirement. And I guess I'll back up for just a second. There is a method for adding items to an agenda that are not contained on an agenda for a regular meeting. There is a method for doing that under certain circumstances, emergency circumstances, items that have been continued from a previous meeting that was held within 5 days. So there are 2 or 3 very limited circumstances under which a regular meeting agenda can be sort of augmented to add additional items. With respect to a special meeting, however, the special meeting agenda is limited to whatever was contained in the notice of the special meeting and the agenda for that special meeting. There is no method for adding items to a special meeting's agenda, and the notice requirements are somewhat different. Members of the commission who are not members who called the meeting are entitled 24 hours notice. 24 hours notice must also be given to media outlets that have requested notice. In emergency circumstances, even that 24-hour notice requirement can be dispensed with. But the emergency circumstances under which that can happen are very limited. The circumstances must be very dire in order to constitute an emergency, such that you can essentially dispense with all notice, although media outlets would be entitled to 1 hour notice. But those are very limited circumstances, not very common at all. At your meetings, the public have certain rights at your meetings. They certainly have the right to attend meetings. Members of the public also have the right to comment on matters that are on the agenda, and they have the right to do that either before the commission considers the item or while the commission is considering the item. But the members of the public need to be given an opportunity to comment on agenda items prior to any action being taken on that item. I think that just makes sense. In order for public comment to have any kind of value, it has to be given before any action is taken on an item. Members of the public are also able to photograph meetings, to videotape meetings. They can do all these things as long as they're not interfering with the meeting. And to the extent any of that activity were to interfere with a meeting, then they could be asked not to do that. But the general rule is members of the public can attend, they can videotape, they can take notes, they can audio tape. They can't be required to identify themselves. We do generally ask that members of the public that intend to speak provide a speaker card that asks for certain information, identifying information about that person. To the extent that a member of the public wanted to speak and did not want to fill out that speaker card, I think that it would be most prudent to allow them to speak. The Brown Act really is designed to promote public participation, and sort of that would require the commission to limit the obstacles that it places to members of the public participating, and certainly limiting anything that would foreseeably have a chilling effect on members of the public being willing to participate. Members of the public also have the right at your meetings to comment on any item that's not contained on an agenda. So you'll see on every agenda there will be an item for members of the public to comment on any non-agendized item. The comments that are being made still must, relate to the subject matter jurisdiction of this commission, but literally can be about anything. And those are the types of circumstances that I indicated before may then sort of prompt some discussion with the commission, or at least prompt the commission or motivate the commission to ask city staff to look into an item, something that's not on the agenda that a member of the public wants to comment on. They have the right to do so, and every agenda provides with an opportunity for them to do so. And I'll just note, every agenda for a regular meeting provides the members of the public with an opportunity to comment on non-agendized items. The summary that I've provided contains a brief discussion on closed sessions. Closed sessions really are an exception to the Brown Act's open meeting requirement, and because it's an exception to the general rule, it's construed very narrowly, very strictly by the courts. The types of matters that can be considered and deliberated on in closed session include certain personnel matters, pending litigation or significant exposure to litigation, real estate negotiations, labor negotiations, consideration of pension fund and investments, and threats to public buildings and essential public services, essentially threats to public safety. Most likely, this commission will not have a opportunity to hear matters in closed session. To the extent that you do, I've included a brief summary of the closed session. There's a few additional notice requirements that must occur with closed session items. In addition to being agendized, the closed session items must be announced prior to the commission going into closed session. In the event any action is taken in closed session, that action must be reported in open session following the closed session. So there's a few procedural things that must occur with closed sessions, but again, probably not something that this commission will be dealing with. And finally, what occurs if there's a violation of the Brown Act? The remedies or the penalties for a violation of the Brown Act are really broad. There's quite a few, ranging from simply voiding any action that's been taken in violation of the Brown Act to injunctive relief that would require the council, the commission rather, to comply with the Brown Act in the future. In the event that a majority of the members of the commission were to take action in violation of the Brown Act intentionally and with the wrongful intent to deprive the public of information to which it is entitled, that would constitute a misdemeanor. So there's a criminal penalty for that. But again, that would require the violation to be committed with the intent to deprive the public of the right to participate. But that penalty is there, so I wanted to mention that. So that was just a very brief overview of the Brown Act. And as I said, the summary I've provided goes into a little bit more detail. The statutory sections that I've provided goes into a lot of detail, and the Attorney General's pamphlet contains some pretty useful discussions related to issues that may come up concerning the Brown Act for you in the future. If you have any questions, I'd be more than willing to.
Any questions or discussion? Thank you, Mr. Adams.
Thank you.
That takes us to new business. We would now like to discuss commission focus areas on the issue of crime reduction. I'd like to call upon Captain Axel Anderson from the Los Angeles County Sheriff's Department to discuss relationships between the City of Lancaster, the LA County Sheriff's Department, District Attorney's Office.
Wonderful. Well, first, congratulations. You with the Sheriff Station are looking forward to a long and productive relationship with you. So we're looking forward to this. Thank you.
Captain Anderson, I'm sorry to interrupt, but could you speak at the podium? For all of us that are speaking in this section, because it's being taped, we're not able to be seen where we're seated. Thank you.
I'll get even with you for this, Shelley. Okay. In terms of the relationship between the city and the Sheriff's Department, I got to tell you, I don't know how it could get any better. I really don't. I suppose this might be the wrong way to term it, but the city has put their money and their resources where their mouth is, absolutely. And our deputies over there at the station feel that very, very strongly. They feel the backing that the city has given them in terms of resources, even in terms of emotional support. That relationship is very, very strong. We all get along together very well. To give you some examples of how the city has kind of devoted resources over and above, I'm going to go down a couple of programs here which really are programs which are not part of what would normally be a standard contract in terms of law enforcement for any of our cities. We've got the LANCAP team, which is 8 deputies and a sergeant and a LET, which is hired by the city, and they are extremely effective out there working on apartments and Section 8 homes. We have our top target-oriented policing team, 6 deputies and a sergeant, and associated with that top team also are our core deputies, who are our 4 deputies who have divided the city up into quadrants, and they're kind of like senior lead deputies, keeping their finger on the pulse of their areas and putting together operations to make sure we're addressing problems in those individual areas. Recently, we created a burglary team, 6 deputies, and also a collateral detective bureau sergeant is part of that. And although they've only been around for what, Don, 2 to 3 months? 3 months? Started in July. They've made already somewhere in the area of 150 high-quality burglary-related arrests and recovered about $150,000 in property. So just, you know, tremendously hard work, but these are all resources, you know, above and beyond the call that the city's providing. We also have CSOs, 13 CSOs, community services officers, who are out there taking burglary reports. This frees our regularly assigned deputies up to do other things, and these CSOs have been really well trained. They take fingerprints, they know how to do an investigation, they interview neighbors, they make sure they wrap these things up so that by the time they submit a report which gets back to our detectives, in general, they've got something to work with. And I'm not sure that was true when our deputies were running around with their workload out there. They often cut corners when it comes to burglary reports. So we're really happy and proud of that CSO program. In addition, the city funds 3 OSS detectives, gang detectives over there. Now they come, OSS comes from a different division, but the city felt strongly enough that gangs are enough of a problem out here in the city that they decided that they needed to fund these 3 extra detectives. Bottom line is, as a result of, I think, some really, really remarkable things that the city has helped us out with, Lancaster Station this year is on the way to making about 15,000 arrests or more. Between the 2 stations out here, last year I believe it was about 30,000 arrests. No reason to believe we're not going to be right there or more this year. In addition, the city has, under Mayor Parris's leadership, has looked into and is currently negotiating with the department to become a research and development station, which means that we are going to be one of the first stations in the county who is going to have, you know, technologically advanced things tried out here, new programs tried out here. We really want to be on top of things and out on the cutting edge, and we're making a move that direction. We're planning on going to a beat system, and not to get into that too much in depth, but really what a beat system does is it gives individual deputies responsibility for a certain area. They buy into that area, they visit with residents, they get to know the businesses, and they take ownership of an individual area. So that gives them responsibility, and I think encouragement to do the best job they possibly can to make sure that area is the best area that they can make it. So that's all interesting stuff, and I really do attribute that to the tremendous support we're getting from the city. I feel very, very fortunate to be the captain of this station with all the support that we're getting right now. It's wonderful. When we move on to the courts and the DA's office, we do run into some problems. And Tom White, who is our presiding judge down there, is a wonderful guy. I've talked with him on many occasions. He's an excellent judge. He's an excellent presiding judge. Bottom line is, they probably need a few more judges, and they probably need a few more courtrooms down there in order to get their workload done. It really is sort of a budget and personnel situation that's slowing them down there. But Tom does get it. He does understand. I've talked with him on several occasions. He understands what we're trying to do in terms of eliminating gangs, and he understands what we're trying to do in terms of dealing with this burglary problem and our efforts to bring down those Part 1 crimes. So I'm impressed with Tom. I think he's wonderful, but I would appreciate it if you could make that one of your responsibilities or projects, is to kind of monitor the courts down there and find out what they're doing. The head DA down there, Mr. Nanthrop, I also believe is a good guy, and he's doing what he can with the personnel that he has down there. But again, you know, if you're making 30,000 arrests out here in the Antelope Valley, and those cases are going to that one court down there, that's a huge, huge challenge, and they do have to pick and choose which are the more important cases that they can prosecute. One of the things that falls, I think, underneath the whole system are some of the, some of the types of crimes that destroy. They may not sound like serious crimes, but they destroy the quality of life in our communities. Vandalism might be a good example of that, and we'd like to see the DA down there take that a little bit more seriously, and do some things to make sure that when we go through all the trouble and the operations and the things that we have to do to take these kids into custody, that we would ask that they're not back out on the street before we finish our reports, and that does happen sometime. So in terms of burglaries, we found that burglaries here in the area have become, I think, a real consideration when we take a look at reducing overall Part 1 crimes. We do have a burglary problem out here, and believe me, our burglary team is really making a lot of good quality arrests, and in fact we've got evidence to show, Don might mention that to you here in a few minutes, to show that burglary rate is finally starting to go down. It's been a tough job. Burglars are a little bit different than some other types of criminals. They're a little slyer, and they're a little tougher. They're a little slicker. But we are beginning to get them under control, and that burglary team is doing a great job. Where we're running into the problem, particularly with our head DA down there, Nanthrop, is that we're not getting a lot of time on these burglaries. I mean, even residential burglars, and even residential burglars that are involved, and we can show through the case in more than one residential burglary or numerous residential burglaries. Our detectives like to call it county lid. A lot of them are getting county lid, meaning the maximum in county jail is 1 year, otherwise you go to state prison. So that kind of brought about that term. But they're getting a county lid. Some of them 3 months, 4 months, 6 months in the county jail, and that's not really appropriate for the types of people that we're taking into custody who are long-term burglars, and 6 months in jail isn't going to do much to interrupt the lifestyle they're living, and it's certainly not going to do much to break them out of their habits. So we would like to maybe have the commission look into that and see if there's something that can be done about that. To wrap things up where our Part 1 crimes are concerned, I'd just like to mention one interesting thing, and Don and I have visited down there with the DA on a couple of occasions. One interesting thing we could do would be to get a vertical prosecutor for our burglary team. And so far we haven't gotten much of a positive reaction out of our head DA down there on this, but a vertical prosecutor on these burglaries I think would really assist us in putting these cases together, prosecuting them properly, and ensuring that they get appropriate sentences for their crimes. It's going to be mighty tough, I think, over the long run to do something about these burglaries if these guys are doing anywhere from 3 months to a year in county jail and they're back at us already. So that vertical prosecutor, in essence, would have expertise in burglaries and follows that case from the time that it's filed all the way up until the guy goes to jail. So it's a much, much more effective method of prosecution, and it puts an expert in there taking care of business where we really need the expertise to be. So those are just a few of the things that I wanted to mention to you this morning. I'm sure we're going to be talking a whole lot more about a lot of stuff. Can I answer any questions?
I have a question. On monitoring the courts that you're saying, are there other cities that do this?
You know, I believe there have been other programs. I couldn't cite you another city, but I do know that other cities have actually put people in the courts to monitor and see how these judges. I think if I'm not mistaken, that usually occurs when a judge becomes known as being ineffective. His sentences are not commensurate with common sense or you know what an effective sentence would be, and so they kind of sit in the judge's courtroom and watch what he's doing. In fact, I think it occurred out here, Don, if I remember correctly.
Well, what Axel's referring to is a court watch system. We tried to put a court watch system together. There's various cities and counties that have put a court watch system together. We don't have one. But Axel is referring to the problem that we had in the juvenile justice system. And we watched it very closely, and there was a change in the justice system over there. We're very pleased with that. So, but it wasn't as part of a court watch system. It was actually part of just taking notes on exactly what was occurring over there, and there was a change.
And if I could add on the Court Watch program, I'll be happy to give you some information on that. I had done some research probably at least a year ago, so I can forward that information to you. It's actually a program that is taking place in various cities in states throughout the nation, and it did actually start from domestic violence cases so that the victim would have a mentor and someone to work with the person all the way through their case. But we see it, and I've talked to other Court Watch programs. I actually spoke to a woman that oversees a Court Watch program in Oklahoma, and she said, for us, it doesn't matter what cases. It doesn't have to be domestic violence only. So what it would do is what Captain Anderson and Lieutenant Downton referenced is residents from our city who may be retired, have the time that they're interested in making our court system better. They sit in the audience and they actually put pressure on the judges and make sure that every single, whether it's the attorney, the judge, the bailiff, whoever is involved in the system is properly doing their job and making sure that everything is handled properly for the victim.
One of the best examples of a court watch system that you guys are all going to be familiar with is Mothers Against Drunk Drivers, MADD. And that's how that all started. It started as a court watch system, and it worked nationwide, everybody's aware of it. And that just started out as a very simple court watch system.
And I think, you know, just to mention one more thing, having been down there and talked to Tom White and Mr. Nanthrope, they do have serious issues that they're facing down there too. They have a facility issue. They don't have enough courtrooms for the amount of arrests that we make out here. They don't have enough judges. They do need more personnel down there working for the district attorney's office. So I understand the whys of some of the things that are occurring down there in terms of you know, pleading cases out for punishments that really are inappropriate, things like that. Sometimes it's just the reality of how the system has to work in order to keep things moving and not have it completely logjam. But I do think that in certain crimes that we believe are important here in our community, we could do more if we could somehow influence them and let them know how important we believe these crimes are to us. Because, you know, our stated mission here over the next year or two is to bring that Part 1 crime rate down. We want it under 300 per 10,000, and that's an awfully difficult thing to do if the whole system isn't working together. The courts, the DA, the Sheriff's Department, the city, they all have to work together.
Would this be part of your sheriff volunteer program or a system which we develop?
Well, we keep our sheriff volunteers pretty busy so far. And I'm not sure, to tell you the truth, how many of our sheriff's volunteers would be interested in doing something like that. It's certainly something that we could look into in terms of helping out. But I think that this is a commission composed of individuals who are, I think, highly appreciated in our community, and I think some involvement directly from the commission somehow, or people that you ask to do so, would really help us out a lot.
Do you happen to know any numbers off the top of your head about how many cases are actually filed by the DA's office per day or per year, or any numbers like that?
Yeah, you know, Don might be able to, he's our DB lieutenant, he might be able to give you some kind of an idea there.
How many courthouses are available to hear these cases here in the Valley?
Let's see, they're working on adding 2 more, and I'm going to say I think we have 6 down there right now that are functioning.
Yeah, we've got 6 courtrooms that are functioning right now, but honestly, they use the whole county. You know, it gets to a point to where they'll move cases down. We use Compton Court, we use the criminal courts building downtown. Most of the felony trials end up down there, quite honestly. So, you know, the answer to that is we've got access to 30 or 40 courthouses.
The main negative off-spin of using those courts down there is it's a terrible drive for victims. You know, they've got to get down there and testify, and it wastes a lot of our deputies' time having to go all the way down there, and when they ought to be on the streets out here. So,
you know, I think maybe one of the things that we need to really discuss this and have some discussion and dialogue on this, but you know, obviously there are issues that you know, that need to be discussed with both the presiding Judge White and probably with Mr. Nanthrope, but perhaps we need a committee or something, some process by which we could maybe have a discussion and to identify what some of those issues are and begin to create a dialogue and begin to, once we identify the issues, then we can move toward developing solutions to those problems. But I'd like to have a discussion about that.
You said earlier that the DA needs to take the arrests more seriously. Is that what you're talking about, as far as?
Not exactly. I'm thinking that perhaps as we get involved, maybe we need to have a committee, develop a committee that would meet with Mr. Nantrip and discuss some of the issues. Perhaps.
Chairman Augusta, Rob Paris, I'd like to just make a recommendation to the commission. I know that Chairman Augusta does know the district attorney over at the courthouse, and so do I. And if possibly the commission would agree that the two of us go over and meet with Judge White and Mr. Nantrop and talk about concerns that have been brought up and bring back some information to the commission, maybe we would have more information as to how we could proceed from there, if that would be the commission's pleasure.
Can we do that under the Brown Act?
Yes, as long as there's not a majority of the members of the commission present.
Just so I understand that, does that mean 4?
Yes.
Do we need to run that on a motion?
And I'm just looking at the city clerk. It could be by a motion, or it doesn't have to be by a motion. It can just be by general consensus.
And to the extent that you just have one member of the commission going to the meeting, I don't even know that you would necessarily need a consensus. It would just be a single member of the commission choosing to go and have that conversation and then report back to the commission.
I think it's a great idea. My question would be is if there's anybody else that would be interested in being a part of that meeting. Not necessarily suggesting myself, but Marvin, I don't know if you'd be interested in going.
I'd love to go.
That'd be a good idea.
So, those 3.
Any other discussion, Doctor? So for the minutes, Commissioner Chris, Rob Paris, and myself will meet with Presiding Judge White and John Nantrop from the District Attorney's Office within, we have a time frame? Schedule a meeting within the next 2 weeks, would that be appropriate?
Why don't we just make sure it's within the next 30 days and report back to the commission either at the next meeting or in the meeting after.
Okay, very good. Thank you.
And if you deem necessary, Don and I can obtain any of these, what we believe to be rather light sentences for you so that you have some documentation of what we're talking about.
If I could just make a request with that as well, and this may already include that because I'm not sure with all the names, but would this discussion also be with regards to the juvenile offenses as well as adult also? Or?
Juvenile offenses are it's a little bit different system. We don't file cases on them. We submit petitions, and so the juvenile system is a little bit different. And juveniles are not held in custody by the probation department unless they can show some sort of violence involved in their crime. So juveniles and the juvenile system is probably even a worse problem for us than the adult system because they really and truly are out. We've arrested them and then found them at parties before we were even done writing all the reports. So that's going to be a tough system because of the different way that the law looks at a juvenile. But it certainly could take take a good looking at, that's for sure.
Commissioner Vieira, we certainly can bring that up to both the judge and the district attorney and report back any information about the juvenile system that would seem relevant to you.
Thank you.
The thing important to remember is there's 2 different systems, and they're under 2 different supervisors and presiding judges and district attorneys, supervising DAs. So it's completely separate. The juvenile system and the adult system are completely separate. So to talk to Judge White and DA Nantrop, they won't discuss anything with the juvenile system because they don't have any jurisdiction.
Part of the problem that you've alluded to, of course, is the case overload. And even though we can maybe recruit 40 courts to take care of some of these problems, they all have their own problem of overload. And what the prosecutors are faced with is, let's suppose they have 60 cases that are scheduled for that day and 4 courts to do them in. Now, the defense attorneys and the criminals know this, and their job is to try and use their volume to leverage better plea bargains, recognizing they can't, if everybody goes to trial, the system will come to a halt. So a lot of the so-called leniency that we see, I think, in some measure, is a function of a totally overwhelmed system trying to keep its head above water.
It is.
I don't know, and part of the problem for all of us who have had the great fortune of spending some time in the courthouse are astonished by the incredible inefficiency of that system in and of itself and the relatively lackadaisical use of time. I know as a jury, people are expected to take a day off work to do 4 hours of work at best during a jury trial. So in addressing these issues, that is, in discussing with the court down there, if there's any way to streamline some of this process, and the other thing, of course, is focusing attention. I think there's a political affection for violent crime getting priority over property crime. And therefore you might end up with less enthusiasm about prosecuting burglars over robbers. But it's this nice article that Jim Cabolta put in here, which I think is really the fundamental truth about crime, and that is it's not really the loss of the television set and the sense of invasion that people have. It's the community sense of fear that changes the way we live and changes the quality of our life, whether we are a victim or not. And burglary probably plays more into that sense of fear, not because it's more violent, but because it's more predominant in how people's lives, the quality of their lives is affected. So the notion, I love the idea about the vertical prosecutor. I think that's a great idea.